Author, co-chair of the Coalition for Divorce Reform, and lawyer Beverly Willett writes about the negative consequences of divorce, abolishment of no-fault divorce, restoration of due process, and fairness and equity in family court. She believes that no-fault divorce violates the U.S. Constitution, particularly the 14th Amendment's Due Process Clause. The procedural protections provided by that amendment include the plaintiff's obligation to assert grounds for divorce and the defendant's right to be heard. This includes the right to cross-examine and call witnesses, offer evidence, and the right to impartial decision-making. But spouses sued for divorce are stripped of these rights with no-fault divorce. The suing spouse need only allege irreconcilable differences or that the marriage is irretrievably broken. Just like in every other lawsuit, before no-fault divorce, plaintiffs had to allege and prove a violation of their legal rights. But lawmakers abolished this requirement in divorce cases, and fault doesn't count. In other words, even if you've done nothing wrong, your spouse can still divorce you against your will, force distribution of all marital property, and compel you to turn over your children for visitation. Willett believes, and a growing body of research confirm, that the fallout from no-fault divorce has been financially, emotionally, and physically devastating to spouses and their children, with increases in poverty, suicide, depression, drug and alcohol abuse, and more. No-fault divorce is unfair, bestowing absolute power on the spouse who wants out for any reason whatsoever. It reduces the marriage contract to one terminable at will, making it no contract at all. It violates the fundamental right to marriage recognized by the U.S. Supreme Court and should be abolished. Adapted from an article written by Beverly Willett and produced by the Law Center. Click the link in the description portion of this video to learn more about them.